Every law that defines an offense falls into one of two categories. The first category is mala in se, evil in itself. And the second is mala prohibita. It's evil by prohibition. A mala in se offense is a crime that is, by the laws of nature and God, a true crime. Examples of this would be murder, rape, robbery, fraud, etc. A mala prohibita offense is one that would not be an offense were it not for the legislature passing a law that makes a particular act a punishable offense. Examples of this would be possessing or smoking marijuana, buying and selling more than 7 cars a year without a dealer's license, not obeying road signs and speed limits, etc. Various laws also only apply to certain groups of persons, not persons outside that group. Example of this would be laws concerning licensed contractors. The state has no blanket authority to require every person who for profit plumbs or installs a lighting fixture or builds a patio deck to apply for or acquire a license. Here's a list of the persons who must have a contractor's license. Any person conducting certain defined types of construction on state property. Any person who has entered into a contract with the state to perform certain defined types of construction. Any person who has acquired a contractor's license and has not properly canceled it. Any foreign corporation doing business in your state. Federal law only defines mala in se crimes that occur within the federal places. In other words, federal law cannot define murder as such term may be used within, say, Florida. That's because the federal government may only define a mala in se crime for use within places that are under the exclusive legislative jurisdiction of the Congress. Compared to a state penal code, there are relatively few mala in se crimes defined with the United States equivalent of a penal code, which is Title 18 United States Code or United States Code Service. Most crimes that are contained within the 18 U.S.C. are actually regulatory in nature, mala prohibita. When dealing with federal law, the trick is to determine through research what is the exact nature and authority of the law being examined. It will fall into one of 3 categories. A true criminal statute, mala in se, that applies to persons and property located within the geographical United States, i.e. Washington, D.C. and other federal lands, U.S. possessions and territories. And a regulatory law, mala prohibita, that applies to persons and property located within the geographical United States, i.e. Washington, D.C., other federal lands, and U.S. possessions and territories, and or to those who have entered into a licensed activity under the authority of the United States. A regulatory law, mala prohibita, that applies to persons and property located within the states of the Union under the enumerated powers of the federal government, which are expressly defined in the U.S. Constitution. The federal government frequently moves in admiralty jurisdiction. The term used and preferred by the government more recently is special maritime jurisdiction. They are the same snake with 2 heads. Admiralty jurisdiction deals primarily, or maybe I should say originally, with ships and occurrences upon the water. This special jurisdiction was a result of the issues of international shipping, questions of ownership over ships and their cargo, prize issues, defeating a ship at sea at battle, piracy, controversies over ship goods when the owners are not in America, salvage of vessels and goods, and various customs issues. When our nation was first founded, admiralty jurisdiction was restricted by the rule of tides. Under this rule, admiralty jurisdiction could only be invoked if the circumstance took place on water or at the dock, subject to the natural forces of the tides. However, over time that yardstick was thrown aside and admiralty reach was expanded by court decisions to embrace all actions previously cognizable under admiralty, but which took place on any navigable waterway under the jurisdiction of the United States. In other words, if it's a navigable waterway, that is the United States federal territory, or if the waterway is used for interstate commerce, certain controversies that arise in such circumstances can be heard in admiralty jurisdiction. It should be noted that the states of the Union also have admiralty jurisdiction when dealing with issues of interstate commerce, or when a state is acting as an agent under agreement with the Secretary of Transportation for the federal government in the enforcement of interstate commerce regulations associated with navigable waterways. It is widely theorized by tax law researchers that IRS seizures are all made under admiralty jurisdiction derived from alleged violation of a customs regulation in the Virgin Islands. The government is currently disputing this argument by stating that federal court actions involving seizure are commenced under the 28 U.S.C. Federal Code of Civil Procedure. Guess what? Title 28 U.S.C. are rules of admiralty equity. The Federal Code of Civil Procedure controls many, but not all, procedural aspects of admiralty actions. Having discussed the difference between civil actions and criminal actions, one might wonder why some offenses contained in civil non-penal codes can result in consequences usually thought to be exclusively for criminal acts, such as going to jail. In most states, there are 2 doctrines that seem to be at first glance in conflict with one another. One item of controlling case law states that if you are engaged in an activity that is cognizable under the authority of one of the various civil codes, These codes can include penalties that are, in the nature, criminal penalties. While the courts were not specific as to when such criminal penalties attach to a civil offense, we can only conclude that they are limited to cases that are regulated through a license or contract. It's only in such a circumstance that the defendant made a prior agreement to abide by the conditions of the code, and is therefore presumed to know the criminal penalties are a part of that agreement. In short, the court appears to be saying, if you don't like the water, stay out of the pool. Laws do not actually metamorphose, but their language is altered over time to obscure the true purpose and intent of the law. One would think that once a law is passed, it would not need to be altered unless some shortcoming becomes apparent, or some circumstance changes that requires the statute to keep up with the times. I think the average citizen would be surprised to learn that statutes are amended to alter the language for no other apparent reason. I stress the word apparent because the legislative draftsmen who propose these changes know exactly what is their purpose. There is a form of law that is not really law at all. It is commonly referred to as case law, also known as decisional law or precedent. Case law is a previous ruling on a point of law by a court of competent jurisdiction. Case law, when used properly, is intended to provide consistency concerning points of law over time. In theory, this allows one person to go into court on a particular subject in the year 2005 and feel confident that the court will make the same ruling on a particular point of law that a neighboring court made in 2003. On the surface, who can complain? Unfortunately, that leaves the meaning and/or application of specific points of law up to just about every Tom, Dick, and Harry who wears a black robe.